Hello and welcome. My name is Alan, and we are back with more Supreme Court. A look at the Supreme Court. Uh, it is cold outside, thus why I am wearing the jacket. It is right now in the morning, just before 9 o'clock. I got back just a few hours ago because I had to do a sleep study, so. Kind of all over the place right now. But anyway. Oh yeah, Supreme Court. Today we are jumping into the Marshall Court. And this will be a big one. The Marshall Court is one of the major Supreme Courts in Supreme Court history. If you review a lot of history or even just reviewing law, you'll go over the Marshall Court. A number of major cases. John Marshall himself was the Chief Justice for 34 years and what was it, 34 and 156 days? Yeah, 152 days. Which, looking through the list, I think I saw there was only like 2 or 3 justices that were in the Supreme Court longer. So not only is he one of the most important, he's one of the longest serving. So he has an important place in Supreme Court history, and this is one we need to pay a lot of attention to. But with it being so big, I'm going to break it up into pieces. We are not just going over Marshall today or Marshall today and the next Supreme Court video. It is going to be about 3 videos in length just to review Marshall and the justices on the Marshall Court. Yeah. This like I said, this is going to be a big one. So let's get started. John Marshall is the new Chief Justice who takes over after Ellsworth resigns. In fact, it is in the last few months, last few weeks, that John Adams literally appointed John Marshall as the nation's 4th Chief Justice. You know, President Thomas Jefferson was about to take over as the nation's 3rd president. But John Adams and Jefferson was supposed to take over, I think at that point it was still around March of the beginning of the year, and he was supposed to take over in 1801. Adams, in his last few weeks as president, appointed John Marshall. He literally served starting February the 4th, 1801. He was approved January the 27th, 1801. So as a last dig, because Adams and Jefferson were kind of on opposite ground. People think, oh, Democrats and Republicans hate each other. It's not a new thing. It has been going on for a while. In fact, we know that John Adams and Thomas Jefferson died on the same day, but one who died, the one who died first, he says, um, I can't remember exact words, but he was talking about curse it. That person's going to live longer than I did. Although they both died the same day, it's kind of, yeah. There was some serious rivalries going on. But anyway, John Adams, in his last Supreme Court appointment, appoints John Marshall to replace Oliver Ellsworth. John Marshall was from Virginia. He served February the 4th, 1801 to July the 6th, 1835, dying in office. But he serves for a total of 34 years and 152 days. He would be Chief Justice through a number of presidents. Marshall himself, actually, Jefferson and Marshall did not see eye to eye, even though Jefferson knew he was very good at what he did. Jefferson had a mentor, George Wythe, who also gave speeches that really helped influence John Marshall to get into law. And of course, George Wythe himself is a signer of the Declaration of Independence, a former governor of Virginia. So there's even a town in Virginia named Wytheville in Wythe County, which both are named after George Wythe. Anyway, let's get into John Marshall and see what. Let's read to you what it says, and it says quite a bit here. He was born in 1755 near what was then known as Germantown, now known as Midland, Virginia, and died in 1835 in Philadelphia, Pennsylvania. Was the fourth Chief Justice of the United States and principal founder of the U.S. system of constitutional law. As perhaps the Supreme Court's most influential Chief Justice, Marshall was responsible for constructing and defending both the foundation of judicial power and the principles of American federalism. The first of his great cases in more than 30 years of service was Marbury versus Madison, 1803, which established the Supreme Court's right to expound constitutional law and exercise judicial review by declaring laws unconstitutional. His defense of federalism was articulated in McCulloch versus Maryland, 1819, which upheld the authority of Congress to create the Bank of the United States and declared constitutional the right of a state to tax an instrument of the federal government. In his ruling on McCulloch, Marshall at once explained the authority of the court to interpret the Constitution, the nature of federal-state relations inherent in a federal system of government, the democratic nature of both the U.S. government and its governing. And during his tenure as Chief Justice, Marshall participated in more than 1,000 decisions, writing more than 500 of them himself. John Marshall was born in a log cabin as the eldest of 15 children of Thomas Marshall, a sheriff, justice of the peace, and land surveyor who came to own some 200,000 acres of land in Virginia and Kentucky, and who was a leading figure in Prince William County from 1759, Fauquier County, Virginia, and Mary Keith Marshall, a clergyman's daughter whose family was related to both the Randolphs and the Lees, two of the Virginia's most prominent families. Of course, the Randolphs we talked about in the second episode of the Supreme Court, Edmund Randolph being Attorney General, and then the Lees, Light Horse Harry Lee, which was one of the major founding fathers, and then I believe it was his son or grandson, Robert E. Lee, who was, of course, the Confederacy's general in the Civil War. Marshall's childhood and youth were spent in the near frontier region of Fauquier County, and later lived in the Blue Ridge Mountain area where his father had acquired properties. His schooling was primarily provided by his parents, supplemented only by the instruction afforded by visiting clergymen who lived with the family for about a year, and by a few months of slightly more formal training at an academy in Westmoreland County. When political debate with England was followed by armed clashes in 1775, Marshall, as lieutenant, joined his father in a Virginia regiment of Minutemen and participated in the first fighting in that colony. Joining the Continental Army in 1776, Marshall served under George Washington for 3 years in New Jersey, New York, and Pennsylvania. His service including the harsh winter of 1777 to 78 at Valley Forge. He eventually rose to the rank of captain, and when the term of service of his Virginia troops expired in 1779, Marshall returned to Virginia and thereafter saw little active service prior to his discharge in 1781. Marshall's only formal legal training was a brief course of lectures he attended in 1780 at William and Mary College, given by George Wythe, an early advocate of judicial review. Licensed to practice law in August 1780, Marshall returned to Fauquier County. I'm not sure if I'm pronouncing that right. Fauquier, and was elected to the Virginia House of Delegates in 1782 and 1784. Attending the sessions of the legislature in the state capital at Richmond, he established a law practice there and made the city his home after his marriage to Mary Ambler in January 1783. Because even though it's in Southwest Virginia is a big place. I live on the far end tip we're literally minutes from the Kentucky border. Um, but Roanoke's considered Southwest Virginia, and it's a few hours up the road here into Virginia. So yeah, Southwest Virginia is a lot bigger than you think. So I'm not sure of that county how it's pronounced. For the next 15 years, Marshall's career was marked by increasing stature at the bar of Virginia and within Virginia politics. Although by 1787 he had not achieved a public position that would have sent him as a delegate to the Constitutional Convention in Philadelphia, he was an active, if junior, proponent of the new Constitution of the United States in the closely contested fight for ratification. That year, Marshall was elected to the legislature that would have taken the first step toward ratification by issuing a call for a convention in Virginia to consider ratifying. He was also elected a delegate to the convention. His principal effort on the floor of the convention was perhaps prophetically a defense of the judiciary article. He then used his acknowledged popularity to gain or build the narrow margin by which Virginia's ratification of the Constitution was won. Shortly after the new Constitution came into force, President Washington offered Marshall appointment as U.S. Attorney for Virginia, a post Marshall declined. In 1789, however, he sought and obtained a further term in Virginia's House of Delegates as a supporter of the national government. As party lines emerged and became defined in the 1790s, Marshall was recognized as one of the leaders of the Federalist Party in Virginia. In 1795, Washington tendered him an appointment as Attorney General. This, too, was declined, but Marshall returned to the state legislature as a Federalist leader. In 1797, Marshall accepted an appointment by President John Adams to serve as a member of a commission with Elbridge Gerry and Charles C. Pinckney that unsuccessfully sought to improve relations with the government of France. After the mission, reports were published that disclosed that certain intermediaries, some shadowy figures known as X, Y, and Z, see the XYZ affair, had approached the commissioners and informed them that they would not be received by the French government unless they first paid large bribes. The reports further revealed that these advances had been rebuffed in a memorandum prepared by Marshall. Marshall subsequently became a popular figure, and the conduct of his mission was applauded by one of the earliest American patriotic slogans: "Millions for defense, but not 1 cent for tribute." Upon his return from France, Marshall declined appointment to the Supreme Court to succeed James Wilson, but he was persuaded by Washington to run for Congress and was elected in 1799 as a Federalist. His service in the House of Representatives was brief, however. His chief accomplishment there was the effective defense of the president against a Republican attack for having honored a British request under the extradition treaty for the surrender of a seaman charged with murder on a British warship on the high seas. In May 1800, President Adams requested the resignation of the Secretary of War and offered the post to Marshall, and again Marshall declined. Adams then dismissed his Secretary of State and offered Marshall the vacant position. In an administration harassed by dissension and uncertain prospects in the forthcoming election, the appeal of the invitation must have been addressed principally to Marshall's loyalty. After some initial hesitation, Marshall accepted. In autumn of 1800, Chief Justice Oliver Ellsworth resigned because of ill health. Adams, defeated in the November election, tendered reappointment to John Jay, the first Chief Justice, but Jay declined. Adams then turned to Marshall, and in January 1801, Adams sent to the Senate the nomination of John Marshall to be Chief Justice. The last Federalist-controlled Senate confirmed the nomination on January the 27th, 1801. On February the 4th, Marshall was sworn in. But at Adams' request, Marshall continued to act as Secretary of State for the last month of the Adams presidential administration. Marshall also briefly served at Jefferson's request as Secretary of State in the Jefferson's administration. So yeah, remember I said Jefferson and Marshall didn't always see eye to eye, but Jefferson knew Marshall was good at what he did. In fact, Jefferson and Marshall were a bit related. Let's see what it was here. They were second cousins once removed. So yeah, they were even related, even though they didn't always see eye to eye. Chief Justice of the United States, under Marshall's leadership for more than 34 years, the longest tenure for any Chief Justice. Remember, I said I saw only like 2 or 3 justices, period, that served longer on the entire list. They were just associate justices. Marshall's the longest serving Chief Justice. The Supreme Court set forth the main structural lines of the government. Initially, there was no consensus as to whether the Constitution had created a federation or a nation, and although judicial decisions could not dispel differences of opinion, they could create a body of coherent, authoritative, and disinterested doctrine around which opinion could mass on and become effective. To the task of creating such a core of agreement, Marshall brought qualities that were admirably adopted for its accomplishment. His own mind had apparently a clear and well-organized concept of the effective government that he believed was needed and was provided by the Constitution. He wrote with a lucidity, a persuasiveness, and a vigor that gave to his judicial opinions a quality of reasoned inevitability that more than offset an occasional lack in precision of analysis. His tenure gave opportunity for the development of a unified body of constitutional doctrine. It was the first aspect of Marshall's accomplishment that he and his court he headed did not permit this opportunity to pass unrecognized. Marshall distinguished himself from his colleagues by wearing a plain black robe, in stark contrast to the scarlet and ermine robes worn by the other justices. Prior to Marshall's appointment, it had been the custom of the Supreme Court, as it was in England, for each justice to deliver an opinion in each significant case. This method may be effective where a court is dealing with an organized and existing body of law, but with a new court and a largely unexplored body of law, it created an impression of tentativeness, if not of contradiction, which lent authority neither to the court nor to the law it expounded. With Marshall's appointment, and presumably at his instigation, this practice changed. Thereafter, for some years, it became the general rule that there was only a single opinion from the Supreme Court. Indeed, Marshall's term was marked by great consensus and stability on the court. Marshall only dissented formally once during his tenure, and between 1811 and 1823, the Supreme Court's personnel did not change, the longest such period in history. This change of practice alone would have contributed to making the court a more effective institution. And when the opinions were cast in the mode of Marshall's clear and compelling statement, the growth of the court's authority was assured. Marbury Madison 1803 was the first of Marshall's great cases, and was the case that established for the court its power to invalidate federal laws and acts found to be in conflict with the Constitution. The foundation of the case and the significance of its ruling must be understood within the historical and strategic context of the time. Shortly before the expiration of President Adams' term, the Federalist-controlled Congress created and Adams filled a number of federal judicial positions. The commissions of the judges had been signed and the seal of the United States affixed to the office of the Secretary of State, Marshall's office, but some of them, including that of William Marbury, remained undelivered. Ironically, Marshall, as Secretary of State, was responsible for delivering these appointments. Offended by what he perceived to be a Federalist court-packing plan, President Jefferson ordered his Secretary of State, James Madison, to halt delivery of the remaining commissions. Marbury successfully petitioned the Department of State for his commission, and subsequently he instituted suit in the Supreme Court against Madison. Although the matter was not beyond question, the court found that Congress had, under the authority of Section 13 of the Judiciary Act of 1789, authorized that such suits be started in the Supreme Court rather than in a lower court. The court faced a dilemma of historic proportions. If it issued a writ of mandamus ordering Madison to deliver the commission, it was clear that such a command would be ignored, thereby undermining the court's influence for generations. But if it failed to issue the writ, the Supreme Court would be seen as cowering in the face of presidential power. Under Marshall's direction, the Supreme Court altered the issue at hand, and speaking through Marshall, the court held that Article 3 of the Constitution did not permit this expansion of the court's original jurisdiction, and that the court could not follow a statute that was in conflict with the Constitution. It thereby confirmed for itself its most controversial power, the function of judicial review, of finding and expounding the law of the Constitution. Throughout Marshall's tenure as Chief Justice, the Supreme Court held only one term each year, lasting about 7 or 8 weeks, slightly longer after 1827. Each justice, however, also conducted a circuit court, Marshall in Richmond, Virginia, and Raleigh, North Carolina. Marshall's conflict with the Jefferson administration erupted once more in 1807 in Richmond, where Marshall presided at the treason trial of former Vice President Aaron Burr, successfully frustrating President Jefferson's efforts toward a runaway conviction. As a result, Burr was freed. With hardly more than 3 months annually engaged in judicial duties at the time, the court's docket was much smaller than it is today. Marshall had much more time to devote to personal endeavors. In 1807, he completed the 5-volume The Life of George Washington. He also served, in 1812, as chair of a commission charged with finding a land and water route to link eastern and western Virginia. And in 1827, he was part of the Virginia State Constitutional Convention. Once the power of judicial review had been established, Marshall and the court followed with decisions that assured that it would be exercised and the whole body of federal law would be determined in a unified judicial system with the Supreme Court at its head. Martin versus Hunter's Lassay, 1816, and Cohen's versus Virginia, 1821, affirmed the Supreme Court's right to review and overrule a state court on a federal question. And in McCulloch versus Maryland, 1819, the Supreme Court asserted the doctrine of implied powers granted Congress by the Constitution. In this instance, that Congress could create a Bank of the United States, even though such a power was not expressly given by the Constitution. McCulloch versus Maryland well illustrated that judicial review could have an affirmative aspect as well as a negative. It may accord an authoritative authoritative legitimacy to contested government action no less significant than its restraint of prohibited or unauthorized action. The ruling, which nearly precipitated a constitutional crisis, upheld the authority of the federal government and denied to the states the right to impose a tax on the federal government. Faced with the daunting task of explaining where the authority of the Congress um, where the authority of the Congress to create a bank is located in the Constitution, Marshall turned to Article 1, Section 8, Paragraph 18, which grants to the federal government the power to make all laws which shall be necessary and proper for carrying out the powers it was explicitly granted in the Constitution. The ruling infuriated states' rights activists, leading several, including Judges Spencer Roane and William Brockenbrough, to admonish Marshall and the court through the press. In an unprecedented move, Marshall replied um, under an assumed name, writing "a friend to the Constitution." In commerce law, Marshall led the court in deciding a number of cases brought in response to the emerging American economy and the government's attempts to regulate it. Fletcher versus Peck in 1810 and the Dartmouth College case in 1819 established the inviolability of the state's contracts, and Gibbons versus Ogden, 1824, affirmed the federal government's right to regulate interstate commerce and to override state law in doing so. Many of Marshall's decisions dealing with specific restraints upon government have turned out to be his less enduring ones, however, particularly in later eras of increasing governmental activity and control. Indeed, it has been in this area that judicial review has evoked its most vigorous critics. Outside the court, Marshall spent much of his time caring for an invalid wife. He also enjoyed companionship, drinking, and debating with friends in Richmond. In general, for the first 30 years of his service as Chief Justice, his life was largely one of contentment. In late 1831, at the age of 76, Marshall underwent the rigors of surgery for the removal of kidney stones and appeared to make a rapid and complete recovery. But the death of his wife on Christmas of that year was a blow from which his spirits did not so steadily or so readily recover. In 1835, his health declined rapidly, and on July the 6th, he died in Philadelphia. He was buried alongside his wife in Shaco Cemetery in Richmond. Shaku. I'm not sure. Probably Shaku since it ends with an E. But yeah, that's the life, a synopsis on the life of John Marshall. And just talking about Marshall on his own has been um, quite the video. But yeah, like I said, hugely important. Some of the big cases are that you see in law. Marbury versus Madison, McCulloch versus Maryland, Gibbons versus Ogden. These are 3 cases, huge cases you'll see if you study law and even history. You'll probably come across these cases. So yeah, John Marshall is someone we need to know about. This being the case, I will go ahead and just make this one video about Marshall himself. And then we'll do 2 videos splitting up the rest of the justices of the Marshall Court. And then a video on the cases. But yeah, this is such a big entry. We have to give it its room. So I will go ahead and put the sources in the description below the video. Let's see. But as always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I'll see you all in the next video. Until then, later.